ዛሬ ማለትም ኤፕሪል 9 በአሜሪካን ፌደራል ፍርድ ቤት USRAP እና ዌልካም ኮርን እንዲሁም የስደተኞችን ጉዳይ በተመለከተ የፍርድ ቤት ቀጠሮ እንደነበረ ታስታውሳላችሁ። የፍርድ ቤት ውሎውን ሙሉውን በቀጥታ ተከታትያለሁ። ለእናንተም ወሳኝ የሚባለው ፓርት አዘጋጅቼላችኋለሁ። በቀጥታ ወደዛ ልውሰዳችሁ፣ ተከታተሉት።
The plaintiffs have raised is there are some factual questions about what the government is able to do and on what time frame that it rather than respond to those specifics today, which I'm not prepared to do, I would suggest that the court require further briefing on that topic, whether by way of a status report or otherwise, so that we can address important factual questions that will help the court decide what needs to happen moving forward. And that might include questions that Your Honor was posing earlier about timing from conditional approval to ultimate entry and things like that. Although we would note I do think it is important to note that the Ninth Circuit Court, I think everybody acknowledges, I hope I'm not overstating what everyone acknowledges, that the reference to the Hawaii case and Section 1182F ultimately does, at least that order does allow the government to apply that part of the executive order. But there are more fact questions, some of which have been addressed in the government status reports, but to the extent the court feels that more updates would be helpful. For example, the timing that security checks, medical screening, travel arrangements, things like that, all of which go into the process of what happens once somebody is conditionally approved to when can they potentially seek entry. Those are fact questions that I'm not prepared to answer right now, but may be helpful in some sort of a filing.
Well, I appreciate your argument and position on the matter. I would think, though, that the information that you would need to formulate a position would be readily available to the government. The court's order doesn't require the government to create a new system from whole cloth. We're talking about a system that was functional as of January 19th, 2025. So I would think that getting the information necessary to give the court some sort of timeline for when the system, frankly, is going to be turned back on would be something that would be easy for the government to put together. I guess the part that I'm struggling with here is that there are two injunctions that have been issued by this court. The first was partially stayed. You've got some qualms about the extent to which that order was stayed, but it seems clear to me that there was a carve-out for refugees that were conditionally approved prior to the USRAP EO. So I've made findings that irreparable harm will befall these people short of immediate relief. So there is an urgency to the matter. So to say that you'll get back to me, which is basically what I'm hearing, is not a satisfactory answer. So what I'll do is I'll come back to where I began with plaintiff's counsel, and that's the AIDS vaccine case and the Supreme Court's instruction to the district court to clarify the obligations the government must fulfill to ensure compliance with the court's order with due regard for feasibility of any compliance timelines. Is there any chance that the parties could meet and confer and come up with some sort of timeline for compliance and check marks? I understand plaintiff's position about giving a date certain for when the lights must be turned back on, but I'm worried that I won't be in a position to gauge the government's compliance if I just say turn the lights on, and there are aspects perhaps that the court did not appreciate or perhaps that the parties did not anticipate. So I want to approach this in a reasoned manner, but with urgency, with haste. So what would you say to that in terms of working together to come up with a compliance time?
ቀሪውን የዳኛውን ውሳኔ ለመስማት ባዮ ላይ ባለው የቴሌግራም ሊንክ አስቀምጥላችኋለሁ። ሙሉን እዛ ላይ ማዳመጥ ትችላላችሁ። ቴንክ ዩ